Very good evening, friends. Today, we are having a session on this case study. It could not be typed actually. So that is why we have put the handwritten case study, and I'll get it typed and I'll share it in the group again. So this is a very interesting case study, and it is somewhat close to a real situation which a person faced some years back. So in this case study, Ram Lal is a retired official who keeps worrying about his son, which is yet unemployed, because all of us as parents are worried about our children, कि भाई, how to settle them and all. One day he comes across an advertisement inviting DCPs, direct channel partners, which has been issued by MLM Limited, which has been published by MLM Limited, which is opening retail grocery outlets all across India on a pan-India basis. This advertisement is for selection of 1,000 such direct channel partners who shall be selected through a process of interview to test their aptitude for this shop. MLM Limited has put up a condition of a security deposit of 10 lakhs against which the company shall be providing them stocks worth rupees 8 lakhs. Manish ji, please. Manish ji.
सर वो स्क्रीन थोड़ी जूम कर लेते हैं आप।
एक मिनट मैं देख लेता हूँ कैसे जूम होगी। ये मेरे हिसाब से मैक्सिमम ही है इसमें, ऐसा मुझे लग रहा है। जूम इन नहीं आ रहा है इसमें, जूम आउट नहीं आ रहा एक्चुअली।
अच्छा सर,
जूम इन से ये कम ही होगी एक्चुअली। क्या ये हैंड रिटन ही है ना?
हाँ मैं समझ गया सर आपकी बात,
वो है
राइट।
कोई मैंने ना ग्रुप में भी शेयर की है, तो आप अपनी स्क्रीन पे भी इसको ओपन कर सकते हैं।
राइट 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 राइट, नो नो ठीक है
हाँ, प्लीज ओपन ऑन योर ओन स्क्रीन, नो इश्यूज। हाँ जी,
दैट्स परफेक्ट।
सो this advertisement is for selection of 1,000 such direct channel partners who shall be selected through a process of interview to test their aptitude. MLM Limited has put up a condition of a security deposit of 10 lakhs against which the company shall be providing them stocks worth rupees 8 lakhs and furniture and fixtures worth rupees 2 lakhs. Now Ramlal is also happy that okay, for the 10 lakhs we are giving, we are getting that much stock and furniture. The space has to be arranged by the direct channel partners themselves. A software for billing and stock updation shall be provided at each retail grocery outlet. And at the end of the day, daily cash receipts shall be deposited in the account of MLM Limited. Direct channel partners shall be provided a commission of 5% to 10% based on the gross sales volume at the end of each month. So at the end of each month, they will be billing and they will be getting. So expenses, if any, at the outlet are to be borne by the direct channel partners themselves. Suppose they hire an employee, or they have to get some cleaning or some air conditioning. So all those expenses, including rent, they have to be shared by the direct channel partners themselves out of the commission which they will be earning. Now, this worked out fine for a period of 6 months. Suddenly, one day, the company, which had its registered office in Mumbai and corporate offices in Delhi, Kolkata, Chennai, and Hyderabad, suddenly vanished from the scene. Now, Ramlal approached an advocate who told him to get in touch with an insolvency professional. Ramlal got in touch with CA Rajesh Saravaji, who is an insolvency professional. And Ramlal told him that the security deposit of 10 lakhs was remitted from his bank account. Now, there is a question here that the security deposit is given by father, but the direct channel partner is son. The shop, which was taken on rent of 20,000 per month, landlord is pressurizing to pay the rent, which is overdue for the past 1 month. So this is the first page. Let us go to next page. For those who joined late, I have already shared this presentation, this handwritten case study earlier today also, and now just 5-10 minutes back in the form of a PPT. You can open it on your own laptop. Next, regarding this security deposit, there was a condition that the security deposit of 10 lakhs was given by the direct channel partners on the assurance that they will be given interest at the rate of 6% subject to TDS. So per quarter, they will be given interest on this security deposit. And in case the MLM Limited is unable to clear the commission bills of the DCPs, which they are required to raise on a monthly basis, depending upon the sales volume generated by them, and ranging between 5% to 10%. So if such commission bills are not cleared continuously for a period of, if they remain pending for a period of 3 months, then the security deposit can be called back by the direct channel partners by giving 1 month's notice. So this was the condition of the security deposit. Now, next page. Ramlal is well connected because he is a retired official. And now he also lodges a complaint with this economic offences wing. So the 1000 direct channel partners, they have formed an association of which Ramlal's son Rohit is also a member. Now they have contributed a sum of rupees 1000 each, and CA Rajesh Sarawat, who is an IP as well, he has been asked to file a joint application on behalf of all the direct channel partners. Now CA Rajesh Sarawat has been handling audit assignment of Ramlal, who has set up a business post his retirement. So in view of the above, please answer the following questions. I hope by now you are clear about the case study. If anyone is not clear about the case study, please raise your hand so that we can discuss it again. Or I can give you some time more so that you can again go through the case study so that we can go to the questions. This is the first page. So please take your own time, or you can read it from your own laptop. Let us devote 5 minutes more to this, and then we'll move on to questions. So in the meantime, those who have already read the case study, they can see the questions. And then we will discuss one by one more than 20 questions which we have framed on this case study. And once you solve all these questions, most of the provisions of CIRP will be clear to you. Those who want to proceed, they can write yes in the chat box so that I can come to know when to start the questions. So as soon as I get 15 yes in the chat box, I'll start questions. If you are unable to decipher a particular word, you can ask in the chat box. Sir, channel partners have sufficient stock in lieu of 10 lakh security deposit. Then where is default? There is a question by Manoj Kumar Mittal ji. But this stock belongs to the company. This stock does not belong to the direct channel partners. The ownership of the stock is with the company. They are, say, at best, Dell creditor agent, commission agents. They are getting commission only. They cannot keep stock as security. It was just to give them a false hope that, okay, stock is lying with us, but that stock belongs to the company, not to them. Hmm. Okay. So I think now people have already, I am presuming that everybody has read. If somebody still wants time, he can write in chat box. Otherwise, we can move into questions. To briefly summarize the case study, there are 1,000, there is a company, MLM Limited. They issue an advertisement in the newspaper. They invite 1,000 direct channel partners who are basically commission agents working for them for grocery outlets, which are being opened all across India. So they have asked for a security deposit of 10 lakhs and they will be providing stocks and furniture in lieu of that. Monthly billing is there. So as soon as stock is depleted through software, the company will come to know and they will replenish the stocks. And they will ensure that at any point of time, there is a stock worth rupees 8 lakhs. 8 lakhs is the market value of the stock. And if anybody wants more stocks, then he has to deposit cash for that extra stock he wants. This goes on for 3 months and then suddenly the company vanishes. And while raising the security deposit, they had given a condition that, okay, we'll be providing you interest at the rate of 6%. And in case we are unable to clear your dues for continuously for 3 months period, then you have the right to call back the security deposit. But the time to call back never came because the company vanished within 6 months. Now, when their hard-earned money uh, went out suddenly, so all these people got panicky and they consulted an insolvency professional how to proceed further. And our questions will be based on that. Manish ji, can we start now? Okay. So the first question, I hope now you are all clear about the case study. So the first question, whether CA Rajesh Sehrawat, he can be appointed as IRP. The fact states that he is the auditor of one of the creditors.
Yes, can be.
If we see the facts, please open the facts regarding independence of professionals. So let me open another PPT also side by side. New share. And, Screen sharing is stopped. Okay. No issues. In this case- So please open the study regarding this CIRP regulations also. Now this is the study, I think, on CIRP regulations. Regarding the CIRP regulations, if we control F independence, then we can find out where the word independence is discussed. We could not find out. Okay. So can anybody tell me the related regulation which covers this independence of professional?
Chapter 2, Regulation 3.
Okay.
That is, he is not a related party of the corporate debtor.
So search for independent.
Okay, right. That is why we could not find out. Independent.
Page number 2.1.83.
So chapter 2, 3. It says an
Chapter 2,
insolvency.
3 explanation.
Okay. So it says a person shall be considered independent of the corporate debtor if he is eligible to be appointed as an independent director. He is not a related party of the corporate debtor. He is not an employee or proprietor or partner of a firm of audit in practice or of a legal or consulting firm in the last 3 financial years. So this independence is vis-a-vis the corporate debtor. But it is not qua the client on behalf of which he is this application is being made. Am I correct on this?
Yeah.
Okay. So this independence has to be seen. So had he been auditor of MLM Limited, then he could not have been appointed. But here he is the auditor of one of the applicants and there's no bar as such. Okay. So the answer to first question will be, let me again share the case study. So the first question which we were
There is no bar.
Okay. So whether CA Rajesh Sehrawat can be appointed as a IRP? Yes,
Yes.
he can be appointed.
Yes.
Now second question. Now where the petition for insolvency shall be lodged?
Where's the?
Where the petition for insolvency shall be lodged, because they have to file with some NCLT. No? NCLTs are spread all over India. So where they will be filing this application? Because basically you should be able to answer it independently without having a look at the options. Yes, at registered office. Umaji is correct. This will be lodged at registered office of the CD, which is in Mumbai. Because I think first page talks of this. This worked out fine for this company, which has its registered office in Mumbai and corporate offices in Delhi, Calcutta, Chennai, and Hyderabad. Okay. So this is correct. Umaji is correct. Now, third question. Whether this 1000 direct channel partners, they form a class of creditors? This is the third question.
Yes.
Acha. So can you point out the exact regulation or any rule for this?
4A.
4A, okay. So let me again share the CIRP regulations. Okay. Acha, 4A is the related regulation for this. So 4A says choice of authorized. I hope my screen is visible or not. 4A. This 4A is visible to you or not?
Yes, sir. Yes.
Okay. So in this, it says on an examination of books of account and other relevant records of the corporate debtor, the IRP shall ascertain class of creditors, any. For representation of class, the IRP shall identify 3 who are not his relatives or related parties, having their addresses as registered with the board in the state or union territory, eligible to be resolution professional, willing to act as AR, and the IR shall obtain the consent of each insolvency professional identified to act as AR. So their consent also has to be obtained in form AB of the schedule. So this was all regarding this AR. Now let me again share the case study and the question. What was the question here? The question here was,
Whether these 1000 channel partners constitute a class.
yes, ha ha ha.
Sir, jurisdiction, where it is written, sir?
Jurisdiction, I have mentioned, no, it has got its office, head office in Mumbai.
Correct? No.
Huh?
Where is the regulation? Where they, because
It
they
is given
have
in section 60. Section 60, section 60, 60. Section 60 of IBC talks of jurisdiction. So if you read section 60 subsection 1, then it talks of jurisdiction. And section 60 subsection 1 says the adjudicating authority in relation to insolvency resolution and liquidation for the corporate persons, including corporate debtors and personal guarantors thereof, shall be the NCLT having territorial jurisdiction over the place where the registered office of the corporate person is located. So 60 subsection 1 talks of this jurisdiction. And in our case, the head office is in Mumbai. So the jurisdiction will be of Mumbai. Just a minute. PPT, CIRP, case study. Okay. So third question is also okay. With whether 1000 direct general partners, they form a class of creditors? Yes, they form a class of creditors. Okay. Now question number 4. Whether
Sir,
this
we haven't answered the question, how do they form a class of creditor?
okay. Regarding this application, I think the answer is given in application to adjudicating authority rules. So let me take you to application to adjudicating authority rules, chapter 1 and rule 2. So Insolvency and Bankruptcy Board of India, insolvency resolution process for corporate persons, regulations. And this regulation is 2. Class of creditors means a class with at least 10 financial creditors under clause B of subsection 6A of section 21, and the expression creditors in a class shall be construed accordingly. So for determining whether a particular set of creditors forms a class, we have to see section 21 subsection 6A under clause B. Now next question. I hope I'm clear on this. Next question. Next question is whether these 1000 direct channel partners can be covered under FCs or OCs. Because they are commission agents also. So they are rendering services to the company as commission
FCs,
agent.
sir.
Huh?
FC.
FCs.
FCs, okay.
because
OCs.
they will be, going ahead in the insolvency process for the deposit amount that they have given, against which
Yes.
interest was payable.
Yes, yes, yes. Because for this, you please refer to page 2 of the case study. And page 2 of the case study says the security deposit of 10 lakhs was given by the direct channel partners on the assurance that they will be given interest at the rate of 6% subject to TDS. And in case the MLM is unable to clear the commission bills of the direct channel partners continuously for a period of 3 months, the security deposit shall be called back by the direct channel partners by giving 1 month's notice. So it is against the time value of money. It is given against interest, and there is a authority to recall also. And in the first page also, there might be some reference. Because this security deposit, it was given for a period of 5 years, basically. Maybe I forgot to mention, but you can add this thing that, okay, this security deposit was given for a period of 5 years. So it is against the time value of money. And there is a provision for interest also. Suppose there was no provision regarding interest, there was no provision regarding time, there was no provision regarding calling back, then it would have been difficult to prove that they are financial creditors. But now, considering the facts, it can be safely presumed that they form a class of creditors. So they are financial creditors as well as operational creditors, because a person can be both a financial creditor as well as an operational creditor. They are financial creditors to the extent of the amount of security deposit which they have given. And here, in some cases, the financial creditor may be someone else and the operational creditor may be someone else. Because as in this case, Ramlal gave the money. So here, Ramlal gave the money on behalf of his son. So whether financial creditor is Ramlal or his son Rohit?
Ramlal.
Yes. So whosoever has given the money, he is, because in the claim form, you have to submit all the details. You have to submit documentary evidence as to how you remitted the money and all those things. So, but there could be sufficient, because amount is 10 lakhs and this whole amount is recalled. So even 10, even if 10 persons qualify, so they will, that will trigger the default under section 4. And
Sir,
there are, yes.
security deposit is it a amount a loan to them? No, I don't think so, because it is okay, it's having an interest and time value. The purpose is not to earn the money on it. When I gave the money for a time value, my intention is to earn interest. Here the purpose is not to earn interest.
No, that is true. But for the company, it is a sort of finance, no? Because it is on this basis alone that they purchased stocks and furniture from the market. Because as in the case of home buyers, if you see the case of home buyers, they also do not give the money to the real estate developer for the purpose of earning interest. But still they are classified as financial creditors. Why? Because ultimately they are the one who are financing the business. So here also the business model is such that the company, if you see the balance sheet of the company, they have not taken any loan from the bank. So who is ultimately financing them? These direct channel partners.
Then if you go to the definitions of the deposit or loan, it doesn't cover the security deposit.
No. But we don't have to go to that definition. We have to go as per IBC, and IBC only says
Then
that it
then
should
I
be,
when
it should
when
be,
it
it should be against the
Financial
time value of money. That much is sufficient. So it is against the time value of money.
but the son is operational creditor and father is financial creditor.
Yes, that is what I'm saying. But in some of the cases, direct channel partners themselves might have funded. So that will depend on situation to situation. In 1000 cases, maybe in 800 cases, direct channel partners themselves funded the security deposit. And in some cases, their relatives funded. So it could differ from person to person. But whosoever has funded, he is the financial creditor. And whosoever is the direct channel partner earning commission based on the sales volume, he is an operational creditor. So they are both financial creditors and operational creditors. I hope this much is clear now.
Yes, sir.
So can we move further on this?
Yes, sir.
So we are clear up to question number 4. Now, fifth question. Suppose application is admitted on 1/1/2023. So by what date the public announcement should be made?
3 days.
Fourth,
Yes.
fourth,
It should be done immediately,
before
but
fourth.
maximum within a period of 3 days. And what is the related regulation for it?
Chapter 3, 6.
Chapter 3, 6 regulation. Okay. So regulation 6 says public announcement. An insolvency professional shall make a public announcement immediately on his appointment as an IRP. And immediately means not later than 3 days from the date of his appointment. Okay. Next question. Next question is question number 6. In which cities this public announcement will be made? Because they direct channel partners, they are spread all over India. So where this application will be, this news public advertisement will be published?
In the location of the registered office.
We can go back again to regulation 6, and it says the public announcement shall be in Form A and to be published in one English and one regional newspaper at the location of the registered office and principal office, if any, of the corporate debtor, and any other location where, in the opinion of the IRP, the corporate debtor conducts material business operations. And in the case study, there is a reference that, okay, it has got its corporate offices at 4 places. In the second para, it says the company has its registered office in Mumbai and corporate office in Delhi, Kolkata, Chennai, and Hyderabad. So at least at these places, this public announcement should be made in newspapers in Mumbai, Delhi, Kolkata, Chennai, and Hyderabad. Another way of finding out where this advertisement is to be made, that, okay, the IRP will make an analysis of the states where these 1000 direct channel partners are located. And he will publish the advertisements in the cities where maximum number of direct channel partners are located. So that could be another way. So for this, he has to take a call. So Prabir Mehtoji, Mumbai is okay, but apart from Mumbai, at other places also, he has to publish this advertisement, to publish this. So one way could be in Delhi, Kolkata, Chennai, and Hyderabad, apart from Mumbai. And another could be making an analysis of the cities in which direct channel partners are located, so that they come to know that this company is under CIRP. Anyway, they have already formed an association. We have already seen that they have formed an association, and through this association, they have approached the insolvency professional. So they will inform the insolvency professional, the insolvency this association also of the direct channel partners. Now, next question. Next question is, in which newspapers? So again, we have to go to regulation 6 for this. And it says in one English and one regional language newspaper. So regional language newspaper in Delhi could be Hindi, in Mumbai it could be Marathi, in Kolkata it could be Bengali, in Chennai it could be Tamil or Telugu. Yes, whichever has got the wider circulation, and wider circulation here means the circulation as per the there is an audit bureau of circulations. I think there is one official source wherefrom you can find out what is the circulation of the newspapers. Next question is,
Hello, sir.
yes, please.
Wider means the largest, or because widest means 2-3 papers will be there. wide circulation.
Okay. No,
Um, uh,
basically, even the number of newspapers published, that data is also available. So based on that, he can make an assessment. Actually, it is left best to the IRP to make his best judgment assessment. And he has
No,
to.
the question is, sir,
Huh.
the question is, IRP chooses where the circulation is less because the cost involved is there.
No. There is not much difference in the cost. And basically, what is the thumb rule? The thumb rule is better you choose the newspaper where government tenders are published. Because government tenders are also published in newspapers on a regular basis. So you better choose those newspapers. Those have the lesser cost. Naturally, one with lesser cost. But if circulation is similar, then the one with lesser cost will definitely be the choice.
No, the question is, if it is not read by the all,
No,
then
that is
they
true.
can.
But actually, normally there are 3-4 English newspapers, and there are some 3-4 another regional language newspapers. Suppose you choose someone, a newspaper will say only where only 100 copies are being printed. Then of course you are in trouble. But normally IRP, they take sufficient care. Whether you get it published in Times of India or Hindustan Times, it doesn't matter much. Next question. Stocks lying with the direct channel partners belongs to whom? Now you have seen the facts of the case. Basically, the stock was given to them because they have to run the business. Stock gave them the added feeling of security that, okay, the material is lying with them. But ultimately, the stock belongs to whom? Only books of accounts can tell this thing. Only the agreements can tell them this thing. So, stocks lying with the direct channel partners belongs to whom? Because in this case, landlord, suppose this business is being run from rented premises. Now the direct channel partners, because they did not get any money from the bank, they are unable to pay the rent also in some cases. So even the landlord is not willing to take them the stock out, because landlord in case of rented premises is claiming the stock unless his rented dues are paid, whether he has got lien on these. So we have to study the concept of lien also from here. And the concept of lien is best given in Sale of Goods Act. And then another thing, the enforcement agencies, because in some cases complaint was being made with the enforcement agency also. So here the enforcement agency also, they want also to claim the stock. So whether they can claim the stock. And direct channel partners, they are claiming the stock as their own because their commission is unpaid. So the stock belongs to whom? Now you are an insolvency professional. So what will be your decision on this point?
So stock belongs to the CD.
Yes, stock belongs to the company. Yes. And even if enforcement agencies, once and a CIRP has been admitted, once an application has been admitted under Section 7.
Moratorium.
So yes, moratorium is in place and they have to vacate the attachment if they have done any. Next question. Later, it transpired that MLM Limited obtained most of the stock on credit basis, and that too from related parties. The sale by such suppliers has been booked on sale or return basis. So in this case, whether those sellers, whether they can have any lien on the stock, because they are in the position of unpaid seller. So what will be the position in this case? Question number 9. Because here we have to see the concept of unpaid seller also. Suppose you have sold goods, but you do not pay up. In this case, they purchased the goods, but they did not pay the suppliers of such stock. Now, whether this unpaid seller, whether they can claim a lien, because that aspect also we have to see as an insolvency professional.
Again, the moratorium will come into place.
Okay. But in that case, the IRP will ask them, okay, the company is under CIRP. Now you also put your claim.
Right.
You also furnish documents. You furnish the documents that, okay, you supplied the goods, but payment was not made to you. We are having copy of the books also. We are having software records also. We will also scan those records and see whether your claim is due or not. Next question. The furniture suppliers and software providers, they had also supplied the goods and services on credit and their dues are also pending. So similar answer to them also that, okay, you also.
They are operational creditors, sir.
Yes, they are operational creditors. They are operational
Even
creditors.
the sellers also operational creditors.
Yes. Both are operational creditors, and IRP will say that, okay, this company is now under CIRP and you also file your claim. We will see. Next question. Next question is, ultimately, Rajesh Sarawatji, who has been appointed as IRP. So this is the balance sheet of MLM Limited. It looks like this. So there are cash and bank balances, 7 lakhs. Then stocks lying with direct channel partners, 2 crores. Because some of the stocks might have been depleted, no, based on the software sales. Investment in subsidiaries or associated concerns, 90 crores. And other current assets, 8 crore 30 lakhs. So total is 100 crore 37 lakhs. And on the liability side, they have got paid up capital 5 lakhs. Then security deposit 100 crores. And current liabilities are there: furniture suppliers 20 lakhs, software suppliers 5 lakhs, and other dues 7 lakhs. And to this we can add the dues which are due for this commission amount. So ultimately, balance sheet looks something like this. So how the IRP shall get, so based on this balance sheet, what is the area where you find that some deeper analysis should be done?
Subsidiaries.
Invested in subsidiaries. Sir.
Yes. Because investment in subsidiaries and associated concerns, and they might have routed the payments out of those investments. So first of all, they invested in those subsidiary company or associated concerns, and then they took out the payment from them. They did not take the payment directly from this company. So first of all, we'll have a deeper look at investment in subsidiaries or associated concerns. Whether they are related parties, mostly they will be related parties. And then we have to appoint a forensic auditor to get a deeper analysis of the things done, because it is just a 6 months old case. So all the cases will come under PUFE transactions. So for PUFE transactions, first of all, we have to critically analyze this investment in subsidiaries and associated concerns. So whether for this purpose forensic auditor's appointment is necessary, or IRP himself can do this thing?
Necessary, sir. Necessary.
No, it is not
IRP
necessary.
No, not necessary, but
Yes.
he has to make an opinion.
Yes. First of all, he has to form an opinion. Then he has to determine the transactions, and then he has to file. He can take
for
help
the-
of forensic auditor, but he cannot
Right.
even hide back behind his report. In most of the cases, it has been seen that even the forensic auditors are not giving any conclusive report. So they are giving report like potential loss and all those things. So because forensic means something which can be proved in the court, which can be established in the court. And they are also hesitant to put it in black and white that, okay, this was the fraud committed, this was the amount which was taken. So this transaction auditor also has to be sounded before handing him the assignment that, okay, you are required to give a conclusive report, because we also know vaguely, where the money has gone.
Sir, opinion should be formed on his own or with the based on the report.
No, opinion can be formed on his own also. There is no necessity as such. It is not compulsory to appoint a forensic auditor. Suppose COC also does not insist, because everything involves cost. And this appointment of forensic auditor also involves cost. So it is not mandatory. If they ask you a question that whether it is mandatory to appoint a forensic auditor, no, it is not mandatory. If COC suggests, okay, then it's okay. Because ultimately cost has to be borne. And even if suppose forensic auditor is appointed and it doesn't point out anything, but the IRP himself is able to find out some transactions, he is able to trace back the transaction to some associated concerns through their bank accounts, through his own connections, because he scanned the balance sheets of subsidiaries also. He came to know who are the auditors of such subsidiary concerns. He knew some of them, and then he submitted an application under section 19(2), asking the adjudicating authority to help him so that the auditors of such subsidiary companies or associated companies, they part with the information which is available with them. So based on that, he may be able to find out. Because I know a case where an IRP, he was from Indian Air Force. Prior to doing this insolvency course, he was basically a cost accountant. And when he retired from Indian Air Force, he took voluntary retirement, and then he became an insolvency professional. So he was able to dig out some figures on his own through some hard work. So even IRP is able to find out. It's not necessary that he should necessarily take the help of forensic auditor.
Sir, but IRP is involved in so many, time-bound actions.
No, that is true, but there are situations where IRP is having only one assignment. So there are situations. So if you have got the time and you have got the interest, you have got the inclination, so you can dig things further. So that depends upon your aptitude, upon the time which is available at your disposition.
And then
So-
again, once these findings are there, then an application has to be made to the A,
Yes.
and then it has to be proved again. So getting a report from the transactional or forensic auditor,
No, that helps,
it's-
definitely. That helps. Yes, definitely. So in this case, now next question. So basically, he will scan through these records regarding these furniture suppliers also. He will see the records. What are the bills available? Software suppliers also. But suppose he comes to know that these furniture suppliers and software suppliers, they are also related parties. Then what will be his stand on this? Whether he will accept their claims or not?
So acceptance of claim depends totally on the
We can accept the
proof.
claim, but they have no powers to vote. They can
No, that is true. But actually,
accept.
he may get independent quotations from other suppliers also who are providing similar furniture. Because if he comes to know that, okay, these parties are related to the directors, MLM Limited, furniture suppliers and software suppliers, then what he will do, he will get independent quotations from other furniture suppliers also, because this information is easily available. Because the type of furniture which was supplied, maybe even customized furniture was supplied, the racks, etc. But still, similar quotations can be obtained, and based on that, he can give his opinion to the COC that, okay, this much is the amount which I
Hello?
think is due to them.
Hello?
हाँ संजीव जी, अच्छा संजीव जी किसी और से बात कर रहे हैं तो प्लीज म्यूट कर लीजिए.
Sir, but then he cannot tell them that, okay, your claim is not admitted. He has to admit the claim based on
No,
the proof,
he will admit actually.
and then he can move to the proof of transaction, and then get it,
Yes,
recalled or.
yes. But nobody stops him from getting independent quotations from some other suppliers. You can put it before COC that, okay, these bills are for 20 lakhs, but I think their claims is not more than 12 lakhs. Because other furniture suppliers are there in the market who are supplying similar kinds of furniture at 12
That
lakhs.
is okay, sir. That is okay. But then the section that he is going to be attracting would be the proof of transaction only, right?
Yes. In this case, he can take recourse to this undervalued transactions.
Undervalued, or extortionate, whatever.
Or extortionate, yes. Next question. How the IRP shall get the stock valued? Now, you imagine a scenario, you are an insolvency professional. The stock is spread. Okay. You are of the opinion that stock belongs to the company, but that stock is lying at 1000 locations. So he is having problem in getting custody and control also. Landlord is not willing to give the keys. He says, okay, I have put my own lock because the direct channel partner, they have not paid me my rent. Number one. Number two, enforcement agency has also got some attachment orders in some states. This registered valuer, he is also asking for a hefty fees because he has to travel all across India. So which seems unviable economically. At some of the places, stocks is just 2 or 3 lakhs or 4 lakhs. So what will be your decision in this as a registered valuer?
As a registered value or as an IP?
As a registered valuer. Suppose you are a registered valuer, then how will you take this? Because he has
We
to
will ask for,
appoint
we will ask
two
for
registered
the,
valuers. Sanjay?
we will ask
And-
for the,
And this has to be done after physical verification of inventory. In case of
Right.
inventory and fixed assets, only this
Physical
valuation can be
verification.
done after physical verification. So physical verification has to be done. And it has to be done item by item.
Mhm.
So in this case, as an insolvency professional, as an IRP, what will be your decision on this? Suppose valuer is asking for heavy fees and which seems unviable economically, then how you will value the stocks? Whether you can appoint your own staff to get the stock valued?
Yes, we can appoint.
Ajay?
कर सकते हैं सर, अपना अपना मैन पावर लगा के करवा सकते हैं और उसका जो कॉस्ट है उसको उसी से क्लेम कर सकते हैं.
नहीं, बट वैल्यूअर अपॉइंट करना तो इट इज एसेंशियल ना. मतलब दिस
मैंडेटरी.
हाँ, ये तो मैंडेटरी है. यू कैन नॉट डू अवे विद दिस थिंग. वैल्यूअर तो आपको अपॉइंट करना पड़ेगा. So what you can do in this situation is that okay, these are usually available items. है कि नहीं? ये ग्रोसरी आइटम्स है. इसमें दाल, चावल, आटा, चीनी, ये सब है. सोप है. So the MRPs are easily available. इसमें कोई दिक्कत नहीं है. Even the software, they are fed in the software also. है कि नहीं? तो आपको क्या करना है कि स्टॉक वाले को बोलना है, वैल्यूअर को, यू हैव टू give him a feedback that okay, this most of the items they can be independently also verified and there is not much deterioration in value. भाई यहाँ पर क्या है, ज्यादा डिटीरियोरेशन तो हो नहीं
Sir,
रहा. हाँ
the
जी.
question is, valuation is not only about the price. It is the quantity, availability of quantity also, that is physical verification also they have to check.
No, that physical verification they will check, but what they can suggest to the valuers is that okay, number one, so pricing is can be independently also verified. So there actually even the software is telling us something. But of course, first of all, you have to physically visit. So because you have to see the condition also, because some of the stock might be damaged also, because some time must have elapsed between the time of filing of the application and the time these operations were stopped. Some of the goods might
Definitely.
some of the goods might have expired also in between. Because for
Stolen
most,
also.
because for most of the food items, the expiry period is not more than 6 months. So depending upon this, you have to take a call and you have to take the COC also into confidence, because ultimately it is the COC who has to pay the fees. But you as an IRP, you first must show your earnestness in appointing the registered valuers. You can obtain quotations from them that okay, and ultimately because the cost has to be borne by the COC, so you take COC also into confidence depending upon the volume of work involved, and you have to do accordingly. But this thing cannot be done away with. So stock valuation is a must. Appointment of valuers is a must. And what is the regulation for this related regulation? Can anybody tell me? Related regulation for this valuers? So if you do Control F valuer, then you may be able to find out okay, where it is.
27.
27, yes. So 27 is the related regulation, and it says yes, 27. So 27 regulation says the resolution professional shall within 7 days of his appointment, but not later than 47th day from the insolvency commencement date, appoint 2 registered valuers to determine the fair value and the liquidation value of the corporate debtor in accordance with regulation 35. And then we have to see the regulation 35 also. The IRP or RP may appoint any professional in addition to registered valuers. Okay, this is different. But now see regulation 35 also. What does regulation 35 says? So regulation 35 says fair value and liquidation value. So fair value and liquidation value shall be determined the following manner. 2 registered valuers appointed on regulation 27 shall submit to the resolution professional an estimate of the fair value and the liquidation value after physical verification of inventory and fixed assets. And if in the opinion of the RP, the 2 estimates of value are significantly different, he may appoint another registered valuer. So that means a 3rd registered valuer who shall submit an estimate of the value computed in the same manner, and the average of the 2 closest estimates of a value shall be considered the fair value or the liquidation value as the case may be. Now this fair value and liquidation value has to be disclosed at what point of time? After the receipt of resolution plans. The RP shall provide the fair value and liquidation to every member of the COC. On receiving an undertaking from the member, that such member shall maintain confidentiality of the fair value and liquidation value and shall not use such value to cause an undue gain or undue loss. Now, whether this fair value and liquidation value has to be shared with the resolution applicant also or not? Because they might ask a question on this.
No, sir.
Whether this
No.
fair value and liquidation value is to be shared with the prospective resolution applicant also?
No, no, no.
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 It is to be shared only with members
COC.
of COC, and that too after obtaining an undertaking of confidentiality. Okay. Let us again go back to our case study. CIRP case study. Okay. So I think we have done up to question number 12. Now question number 13. Who will bear the traveling / other expenses of IRP? Because in this case, IRP or this valuer, they will also be required to travel. So who will bear their traveling expenses?
Part of IRP cost?
Yes.
So mostly
So-
traveling is covered in the valuer's appointment only.
Even IRP might be required to travel now, because IRP will be taking custody and control. So without actually traveling, how you will obtain custody and control? You have to travel at all the places.
Right.
Only then you will be able to take custody and control now. Because the valuer will not get into all this trouble now. Valuer will get the custody from you only. You cannot ask the valuer to go directly to the site and get the physical verification done. So you have to assist him. So first of all, you have to take the custody and control. Only then you can ask the valuer to get the-
Regulation for taking custody control, sir? Any timeline also there?
Yes. There is a timeline and there is a regulation also. So CIRP regulations, you do this control F. Custody and control, they are the duties of IRP or RP. No? So I think section 18 and section 25 will give you an answer. Section 18 talks of he will collect all information relating to assets and he will take custody and control of assets. Section 18, subsection F talks of this thing. So as an IRP, it is your duty. It is one of your foremost duties to take custody and control. So section 18 F talks of this. And even as a liquidator, you have to take the custody and control. And there is a penalty section also for this. Insolvency and resolution process for corporate debtors. Section 70 talks of punishment for misconduct in course of CIRP. So if someone does not disclose details of property or transactions or information to RP, does not deliver control or custody of part or property to RP, does not deliver books or papers of CD in his control to RP, then there is a penalty of 1 lakh to 1 crore or imprisonment of 3 years to 5 years. Section 70 talks of this. Now let us see the next question. So I think we have done up to question number 13. Can the COC recommend early liquidation in this case? And where are the provisions regarding this early liquidation? Is there any concept of early liquidation? Early liquidation basically means without investing prospective resolution applicants. So if the COC feels there is nothing in the company, then they will not waste their time. So can anybody tell me the related regulation for this? That okay, without inviting resolution applicants, you just recommend liquidation. Let us do some control F in CIRP regulations. And let us see early liquidation, whether there is any concept, whether anything written directly on this. So early liquidation as such is not there.
Now, how COC will come to the conclusion that without any resolution plan, suppose when resolution plan is not acceptable to them, then only they can recommend that. Till such time, whether they have power.
Yes, they have got power. It is there in the code itself, even without, because suppose there is a software company, there are no assets in the company or assets are not of much value. Then they ultimately know that if there are no assets in the company, who will come as a resolution applicant? So they can recommend early liquidation also. But where it is written, that we are trying to find out. It is there in IBC. Speed is of the essence. Speed is of essence for the bankruptcy. Just a minute, let me share the screen. It says that speed is the essence. Speed is of essence for the working of the bankruptcy code. I'm reading from the Bankruptcy Law Reforms Committee report. The shorter insolvency resolution period, the committee felt would trigger quicker decision making by the creditors about the fate of debtor. And if the resolution fails, the liquidation value of assets will not suffer a greater fall or diminution. Suppose they take 1 year or 2 years, then the stock will also be spoiled in the meantime. The committee noted that delay causes value destruction because these are the grocery items. Suppose after 1 year, they may not be of any value. So please try to find out where it is written.
So there's a case law on the page 2.1.121.
Page number?
2.1.121.
Okay. 121. Okay. Yes. And the case law says, so I'm reading from the compendium, section 29, along with the section 29, it is written, it is not necessary for COC to follow all the procedures under the CIRP if the plan submitted by the promoters of the corporate debtor being MSME. This is the case law you are reading?
Yes, yes. It broadly says that COC not to follow
causes the maximization of the assets. It
procedures.
says the resolution
That
plan
is the
of-
best resolution plan.
No, that is okay. Resolution plan offered by the promoter being MSME was approved by the committee and thereafter it was confirmed by Honorable Adjudicating Authority. Said order was challenged by one of the interested resolution applicant. No ground on the plan. No, this is not the exact case, but I'll get back to you on this. The COC has got this power. They can recommend without, just let me see the powers of COC. So in powers of COC alone, you will find it out. Mohanji, please. Mohanji.
Yeah, section 33.
Section 33.
If you read section 33, subsection 2.
Okay. Section 33, subsection 2 says, where the RP at any time during the CIRP, but before confirmation of resolution plan, intimates the adjudicating authority of the decision of COC approved by not less than 66% to liquidate the corporate debtor. The adjudicating authority shall pass a liquidation order as referred to in subclauses 1, 2, and 3 of clause B of subsection 1. For the purpose of this subsection, it is hereby declared that the committee of creditors may take the decision to liquidate the corporate debtor at any time after its constitution under subsection 1 of section 21 and before the confirmation of the resolution plan, including at any time before the preparation of the information memorandum. Thank you very much. Because this section 33 subsection 2 read with the explanation talks of clearly that even preparation of information memorandum may not be done, because if COC feels that there are no assets and liabilities, why they will waste their time in preparation of information memorandum? So even this information memorandum may not be prepared and early liquidation may be recommended if there are no assets in the company. Thank you, Mohanji. So, because I also remember that there is something, but I was not able to remember the exact section. So the exact section for this is section 33, subsection 2, read with the explanation. Next.
सर इसका मतलब कि 54 डेज के पहले ही करना होगा ना ये
है?
आईएम करते हैं बनाते हैं 54th डे तक।
भाई वो क्या कह रहा है? वो कह रहा है भाई आपने बनाना नहीं बनाना मत बनाओ। अगर आपकी कंपनी में कुछ जान ही नहीं है तो क्यों नाटक करते हो? हर चीज में IRP का भी तो बिल बढ़ रहा है ना महीने के महीने। वो भी कह रहा है मुझे 5 लाख रुपए पर मंथ दो, कंपनी में कुछ जान ही नहीं है। मान लीजिए एक
जी
सिचुएशन
जी
बता रहा है, तो देयर कुड बी सिचुएशन वेयर देयर आर नो एसेट्स इन द कंपनी, है ना? तो while they will increase the expenses unnecessary, भाई जितना the longer the CIRP, the more the expenses.
ठीक है, अर्ली स्टेज में ही इसको होना है इसका मतलब।
है हाँ, अर्ली स्टेज में भी कह देगा ना भाई ठीक है कि भाई आप तो लिक्विडेशन करो। जब कंपनी में जान ही नहीं है तो क्यों इन्फॉर्मेशन मेमोरेंडम बनाओगे, नाटक करोगे और रेजोल्यूशन एप्लीकेंट कोई आएगा नहीं और 4 महीने और वेस्ट कर दोगे। ये 10 लाख रुपए महीने ये प्रोफेशनल बैठा हुआ है, 4 महीने में 40 लाख रुपए का ये बिल बना देगा। 40 लाख रुपए की टोटल कंपनी नहीं है, ये है ना?
जी जी सही बात।
क्योंकि क्या है, हु आर सिटिंग इन द COC, बैंकर्स आर वेरी वाइज because they are there to take their money back, not to spend more.
Sir, bankers are wise. IBC could not have been there.
No, that is another angle. But while sitting in COC, they see to it that no unnecessary expenditure is done. That was my point actually. So there is a concept of early liquidation also, as given in explanation to section 33 subsection 2. Next question. Who will get the custody of stock? So now it is amply clear that the custody of stock will ultimately go to the IRP. IRP will take the custody and control. And if there is any problem, if there is any law and order problem, then he will approach the adjudicating authority to take custody and control. Suppose some landlord is playing some tricks, so then he will get an order from the adjudicating authority. Next is how will the AR be selected? Now you are an IRP, you are selecting AR, so it will be on the basis of what? How you will select? There are 1000 direct channel partners spread all over India. Now you have to select ARs. So how AR will be selected? So first of all, because this also has to be done even prior to public announcement, because in public announcement you have to give 3 choices. So what is the process? First of all, ये इको हो रहा है उसमें कुछ, अपना माइक म्यूट कर लीजिए प्लीज, जिनका भी माइक है। अभी तो किसी का भी anyway, हाँ. So first of all, what you have to do is you have to analyze the addresses of all the direct channel partners. Then you have to classify them into different states depending upon where the NCLTs are situated. Now you have to correlate them with the number of insolvency professionals which are available in that state or nearby states. And you have to see the highest number of direct channel partners are in which 3 states. And then you identify the 3 insolvency professionals. You take consent that okay, they will be willing to act as AR, and then you publish their names in the public. And out of those 3, the direct channel partners will be opting for one, and the one which gets the highest number of votes will be selected as the AR. So this is the process for selection of AR. Next question. How will AR communicate with 1000 direct channel partners? Related regulation for this? Control F. Let us do some control F.
16A6.
Huh?
16A6.
16A.
Right.
Okay. So 16A talks of authorized representative, and it says the IRP shall select the insolvency professional who is the choice of the highest number of financial creditors in the class in form CA. So there could be question on any, in which form this consent has to be obtained. Received under sub-regulation 1 of regulation 12 to act as the authorized representative of the creditors of the respective class, provided that the choice for an insolvency professional to act as authorized representative in form CA received under sub-regulation 2 of regulation 12 shall not be considered. So suppose there is some latecomer, so their choice will not be entertained. Suppose some creditor out of this 1000, so some did not express their choice at that point of time. So whosoever selected is final, number 1. Now, this IRP, within 2 days of the verification of claims, so he will apply to the adjudicating authority for appointment of AR. And any delay in appointment of AR shall not affect the validity of any decision taken by the committee. But now we have to see the author. Yes, here is the answer. Sub-regulation 9. 16A, sub-regulation 9. The authorized representative shall circulate the agenda to creditors in a class. Suppose voting has to take place on a particular agenda item. So he will circulate the agenda to creditors in a class and may seek their preliminary views. So first of all, he will seek their preliminary views on any item in the agenda to enable him to effectively participate in the meetings of the committee, provided that the creditors shall have a time window of at least 12 hours to submit their preliminary views. So he will give them a time window of at least 12 hours to submit their preliminary views. And the preliminary views, they are not considered as voting instructions. And the said window opens at least 24 hours after the authorized representative seeks preliminary views. So this is how he will communicate with the creditors in the class. Next question. Next question is how will the AR communicate with 1000? Who shall bear the fees and expenses of authorized representative? Who will bear?
COC.
And related regulation for this? So we have to see the insolvency resolution process cost. So where we will find this, where the meaning of insolvency resolution process cost is given. Yes. So in regulation 31 talks of this, that the insolvency resolution process cost shall mean amount due to suppliers of essential goods and services, fees payable to AR under regulation under 39. So this amount fees payable to authorized representative is, and in this case, what will be the fees payable to AR? Because there are 1000 channel partners. So what will be the fees per meeting? Can anybody tell?
20,000 per meeting. 20,000 per meeting.
Okay. Yes. So 100 to 1000, it is 20,000 rupees per meeting. Let us see the next question if there is any. And can anybody tell me the minimum number of direct channel partners who can move this application?
10.
Minimum number of channel partners. 100?
100,
Because
100, right?
10 lakhs
10
is
lakhs.
the amount, na? So why 100?
1 crore के लिए 10 होना चाहिए, 10.
But for a class of creditors, कहीं अलग से भी तो दिया हुआ ना? 10% or 100, whichever is lower. So 10% of 1000 is also 100 or 100. वो भी तो है ना, आपको 21,6 से भी तो देखना है ना. 1 crore तो ठीक है. 1 crore एक का हो, suppose security deposit taken from each of them is 1 crore, तो इसका मतलब तो एक भी कर सकता नहीं. It is not that. तो एक तो नहीं कर पाएगा ना. So you have to see section 21 also. 21 में क्या बोलता है? For a class of creditors, minimum number is 10% or 100, whichever is lower. यही बोलता है ना? तो Umaj is correct.
Sir, but this is a financial creditor, right?
भाई फाइनेंशियल क्रेडिटर में भी ऐसा है ना, ही इज नॉट ए फाइनेंशियल क्रेडिटर, ही इज बिलोंग्स टू ए क्लास ऑफ क्रेडिटर्स. तो क्लास ऑफ क्रेडिटर्स में वन पर्सन कैन नॉट मूव एन एप्लीकेशन, चाहे 1 crore हो जाए उसका. आई हैव गिवन यू अनदर क्वेश्चन ना. सपोज द सिक्योरिटी डिपॉजिट गिवन बाय ईच ऑफ देम इज 1 crore, देन कैन वन क्रेडिटर मूव एन एप्लीकेशन? नो, बिकॉज ही बिलोंग्स टू ए क्लास ऑफ क्रेडिटर. Had he been a banker, then even one bank can move an application. So this is the difference. You go to section 7 and section 7 answers this question. So section 7 says provided. So in section 7 there is a proviso after subsection 1, and this proviso says provided that for the financial creditors referred to in clauses A and B of subsection 6A of section 21, an application for initiating CIRP against the corporate debtor shall be filed jointly by not less than 100 of such creditors in the same class, or not less than 10% of the total number of such creditors in the same class, whichever is less. So this proviso is there. So if you belong to a class, then you are governed by this proviso.
Class
So I
कैसे,
think we can, हाँ जी,
class कैसे define किया इनको हम लोगों ने?
क्लास का तो
Which
बताया ना
section?
आपको, एप्लीकेशन टू एडजुडिकेटिंग अथॉरिटी रूल्स में, रेगुलेशंस
Sir,
में ही है वो. हाँ,
सर 1 crore भी होना चाहिए ना?
1 crore तो मिनिमम होना चाहिए, बट 1 crore alone is not sufficient.
Sufficient. Okay.
By suppose the security deposit given by each of them was 1 crore, then whether one person could have initiated? No, the answer is no, because they belong to a class. A class of creditor means creditors which are governed by similar set of conditions. Similar conditions as to repayment, as to interest, etc. I gave you the example of depositors, 5,000 depositors, debenture holders. So similarly, these direct channel partners, they belong to a class of creditors. But suppose there are bankers, so they are not a class of creditors, they are financial creditors. So for assessing their applicability of section 7, we have to go by the proviso to section 7 subsection 1 proviso, which talks of at least 10% or 100, whichever is lower. So 10%
Sir,
is
class
also
of
is
creditor
100.
के लिए आपने,
Huh?
for class of creditor, what regulations have you told, sir?
Regulation 2 में है वो, अभी तो बताया था. Let us go again to regulation 2.
Class of creditor के लिए, sir.
हाँ हाँ, रेगुलेशन 2 पर जाइए. रेगुलेशन 2 सब रेगुलेशन 1 सब रेगुलेशन AA. Class of creditors means a class with at least 10 financial creditors under clause B of subsection 6A of section 21, and the expression creditors in a class shall be construed accordingly. तो आपको 21 का 6A पढ़िए. 21 का 6A gives you clarity on what is a class of creditors. 21 का 6A क्या बोलता है? Where a financial debt is in the form of securities or deposits, and the terms of the financial debt provide for appointment of a trustee or agent to act as authorized representative for all the financial creditors. Such trustee or agent shall act on behalf of such financial creditors. Suppose a company has issued debentures. Okay? So in case of debentures, normally for every 500 debenture holders, a debenture trustee is appointed as per SEBI regulations in case it is a listed company. So in that case, the debenture trustee, he will act on behalf of all such financial creditors. So this is one class. Number two is owned to a class of creditors exceeding the number as may be specified, which is given in regulation, 10% or 100, other than the creditors covered in clause A. So clause A talks of debenture holders or subsection 6. The IRP shall make an application along with list of all financial creditors containing the name other than the IP to act as AR. And this classification, who will decide who belongs to a class? This has to be done by the RP. And let me tell you the regulation also. I think it is given in section. Just let me give you the related section also.
सर इसको क्लियर करते हैं लोगों को कि ये क्लास ऑफ ये इसका क्लास का जो ये हुआ, ये कब से हुआ? अलॉटेज के केस में हुआ ना?
नहीं 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 नहीं, ऐसा है, क्लास का मतलब अलॉटेज ही नहीं है। क्लास देखो, डिवेंचर होल्डर्स की भी क्लास हो सकती है।
तो ये concept
सबसे पहली बात तो ये है कि ये क्लास डिसाइड कौन करेगा कि वेदर ए पर्टिकुलर सेट ऑफ पीपल बिलोंग्स टू ए क्लास। ये दिस हैज टू बी डिसाइडेड बाय द आईआरपी बेस्ड ऑन द बुक्स। वो बुक्स को देखेगा और बुक्स के हिसाब से देखेगा कि भाई ये कोई क्लास ऑफ क्रेडिटर बनती है या नहीं बनती। इसका डिसीजन कौन लेगा? ये आईआरपी डिसीजन लेगा।
जी,
पहली बात तो ये है, ठीक है। उसके बाद में अब ये क्लास होम बायर्स की होनी जरूरी नहीं है। इट इज नॉट नेसेसरी दैट दे आर होम बायर्स ओनली। दे कुड बी डिबेंचर होल्डर्स, दे कुड बी डिपॉजिट होल्डर्स। ये यहाँ पर भी ये क्लास बन रही है ना पर्टिकुलर, क्योंकि सबका सेम रेट ऑफ इंटरेस्ट है, सिमिलर कंडीशंस हैं, तो वो चीज है। मैं आपको एग्जैक्ट बता रहा हूं अभी।
सर क्लास ऑफ क्रेडिटर्स का कांसेप्ट पहले से है,
और क्या, ये तो पहले से ही है।
हम अलॉटेज के साथ नहीं आया ये।
ना ना ना, अलॉटीज लोगों को ये ऐसा इंप्रेशन है कि अलॉटीज के साथ है। अलॉटीज का कोई मतलब नहीं है इससे। अलॉटीज आर ऑल्सो ए क्लास, बट देयर कुड बी अदर क्लासेस ऑल्सो। ऐसा नहीं कि खाली होम बायर्स ही क्लास है। जैसे मैंने बताया ना, 21(6) पढ़िए ना आप। 21(6) में क्लैरिटी है, और 21(6) से अलावा भी मैं आपको कुछ बताता हूँ।
अच्छा है, आप कंसेप्ट क्लियर हो गया।
हाँ, तो ये कॉन्सेप्ट क्लैरिटी ही तो इम्पोर्टेंट है मेनली, तो इसमें यही है और क्या है।
21(6) of the code, right, sir?
हाँ हाँ,
ये regulations.
नहीं नहीं, कोड। ये आप देखेंगे, ये मैं आपको बताता हूँ। इंसॉल्वेंसी एंड बैंक्रप्सी कोड ऑफ इंडिया, इंसॉल्वेंसी रेजोल्यूशन प्रोसेस फॉर कॉर्पोरेट पर्संस रेगुलेशंस, इसका चैप्टर 1 देखिए। चैप्टर 1 में यू गो टू रेगुलेशन 2AA। सो क्लास ऑफ क्रेडिटर्स मींस ए क्लास with at least 10 financial creditors under clause B of sub-regulation 2, and creditors in a class shall be construed accordingly.
3.6.3
नहीं, रेगुलेशन 2 है। रेगुलेशन 2 में क्लास ऑफ क्रेडिटर्स बताया है कि क्लास ऑफ क्रेडिटर होता क्या है। तो क्लास ऑफ क्रेडिटर में कम से कम 10 होने चाहिए, 10 से कम पे क्लास ही नहीं बनेगा।
ऐसे अलॉटेज केस में तो 100 है ना मिनिमम सर।
और वो तो है, बट कह रहा है कोई भी आपने क्लास बनानी है तो क्लास में कम से कम 10 होने चाहिए। 10 से कम पे तो क्लास ही नहीं बनेगा।
जी सर, 21AA में है ये क्लास ऑफ।
हाँ हाँ हाँ। और
तो
अब
class
इसका
कहाँ defined है
डिसीजन
सर?
इसका डिसीजन कौन लेगा? इसका डिसीजन लेगा बेस्ड ऑन द बुक्स ऑफ अकाउंट, ये IRP।
IRP देगा। जी सर, जी सर, वेरी ट्रू। कंफ्यूजन दूर हुआ बहुत, इसका कंफ्यूजन क्लास ऑफ क्रेडिटर्स का था सर, बहुत
हाँ
अच्छा।
हाँ बिल्कुल, ऐसे बहुत सारे कंफ्यूजन है, देखो सभी को होते हैं, हमें भी होते हैं। और जैसे जैसे जिसको बार बार पढ़ते हो तो आपको क्लैरिटी आती है इसमें।
सर क्लास कहाँ पे डिफाइंड है?
भाई क्लास आपकी डिफाइंड है, मैं बता रहा हूँ आपके ना, जहां पर बुक्स ऑफ अकाउंट्स है ना, तो बेस्ड ऑन द बुक्स ऑफ अकाउंट जब देखता है ना IRP, तो वो क्लास ऑफ क्रेडिटर आइडेंटिफाई करता है।
नो सर, रेगुलेशन, स्पेसिफिक रेगुलेशन।
अभी बता रहा हूँ। मैंने आपको हिंट दे दिया कि जहां वो बुक्स ऑफ अकाउंट्स देखेगा ना, तो बुक्स ऑफ अकाउंट देख करके ही वो क्लास ऑफ क्रेडिटर्स को आइडेंटिफाई करेगा, क्योंकि वो उसी के बेसिस पर तो देखेगा ना कि भाई कुछ अपना AR बनाना है या नहीं बनाना। अगर कोई क्लास ऑफ क्रेडिटर ही नहीं है तो नो AR, क्योंकि ये सब काम पब्लिक अनाउंसमेंट से पहले होने हैं। और ये जो क्लास ऑफ क्रेडिटर, एक और बात बता दूं, इट इज ओनली इन केस ऑफ फाइनेंशियल क्रेडिटर्स। ऑपरेशनल क्रेडिटर में ऐसा कोई डेफिनेशन नहीं है। ऑपरेशनल क्रेडिटर में एवरीबडी हैज टू अप्रोच सिंगली, वहां ऐसा कोई क्लास वगैरह डेफिनेशन वाली बात नहीं है। तो वहां
In
पर
case of
ज्वाइंट मूवमेंट नहीं हो सकता, वहां सिर्फ इंडिविजुअल मूवमेंट ही हो सकता है। एक आदमी का ही 1 करोड़ होना चाहिए।
So apart from bank, all the financial creditors can be part of a class.
वो डिपेंडिंग अपॉन द बुक्स, उनका टर्म्स क्या है, टर्म्स एंड कंडीशंस डिसाइड करेंगे ना।
हाँ, मतलब क्लास नॉन बैंकिंग में बन सकता है, राइट?
हाँ 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 बिल्कुल बिल्कुल। उसमें तो उल्टा कर दिया बैंक्स में, तो बैंक्स में इज जस्ट द रिवर्स। सपोज a loan has been financed by a consortium, so all the members of the consortium will be covered under this जो COC, सभी members of COC बनेंगे।
Regulation 21AA of class of creditors.
हाँ वो तो है ही। उसके अलावा ये है कि क्लास ऑफ क्रेडिटर आइडेंटिफाई कौन करेगा, ये आइडेंटिफिकेशन का काम है IRP का। भाई बुक्स में तो ऐसी कोई क्लास होती है ना, अगर आप बैलेंस शीट देखो तो उस बैलेंस शीट में तो कुछ लिखा नहीं होता कि ये क्लास ऑफ क्रेडिटर है या नहीं है। तो वो कौन काम करेगा, ये IRP काम करता है, क्योंकि उस क्लास ऑफ क्रेडिटर से ही पता चलता है भाई इनके लिए कोई AR चाहिए या नहीं चाहिए। ठीक है जी, तो आई थिंक वी कैन रेस्ट हियर। आज काफी डिस्कशन हो गया, और मेरे हिसाब से वी गॉट अ रीविजिट ऑफ द वेरियस रेगुलेशंस आल्सो। तो दिस वे वी आर एबल टू रिवाइज द रेगुलेशंस। ऐसा होता है खाली रेगुलेशन पढ़ते रहो, उसको रामायण की तरह, कुछ समझ में नहीं आता। लेकिन अगर आप इस तरह से पढ़ेंगे ना, क्वेश्चन आंसर फॉर्मेट, तो आई थिंक इट गिव्स यू